And now, live from Lynnwood, Washington, the defender of justice sings the Hit and Run Shuffle.
You were driving along, singing a song. I hope you were not smoking a big glass bong. You did not see that pickup truck. You couldn't stop in time, so you're out of luck. You know you should have stayed, but you were afraid. You drove on home, you were called on a phone. Knock on the door, and now there is a cop. You are charged with hit and run. So yes, I should keep my day job. But for anyone watching this video, luckily my day job is as a defense attorney. My name is Fryrear, and I'm the defender of justice. Defender of justice. Defender of justice. Defender of justice. I'm here today to tell you about the 3 biggest mistakes that people typically make when fighting their hit and run charge in Washington state. So the first mistake that people make when fighting a hit and run charge in Washington state is not involving their insurance company. So what is hit and run? Hit and run is when you run into some other property, be it an attended vehicle, that means with someone else in the vehicle that was driving it, or a mailbox, or a fence, or a parked car with no one in it. That's a hit and run charge if you don't stay at the scene, and in case there's someone in the car, give them your driver's license and your insurance, your contact information. If there's no one at the property, it's a fence or a parked car, then you need to leave your information, your driver's license, your phone number, your name, your address. And let's say you just run into some bushes, or you go over the road, you skid and you crash into a street sign. Well, then you're supposed to contact the authorities and let them know what happened. And so it's a pretty strict liability statute. So if you get charged with hit and run, the first most common mistake that people make is not involving their insurance company. So plenty of our clients don't want to have their insurance company involved. And that's because they're afraid, well, my insurance rates will go up if they know that I'm involved in an accident, or they'll think less of me if they know I'm involved in an accident. And while that makes sense to feel that way, that's not a good strategy to defend a hit and run case. And the reason for that is, in a hit and run case, there's a way to get your case dismissed through something called compromise of a misdemeanor. So in a motion that your defense attorney could make to dismiss your hit and run case under the statute called compromise of a misdemeanor, what's important there is that the victim appear in court, and that means in writing, and state they've been civilly satisfied for the damages that you caused when your car ran into their property. And so let's say another car got damaged, you ran into them, you rear-ended them, and they have $2,500 worth of damage. Well, some people don't have the money to pay that out of pocket. If the insurance company pays it, then we have a better chance as the defense attorneys to ask the owner of the other property to sign off on a release of liability. And if they do sign off on that release of liability, where they say, yeah, I've been totally compensated for my damages, then the court can dismiss your case. That means no conviction, no criminal record, no fines, and most importantly, no license suspension. So again, if you were insured, usually we want your insurance company involved in trying to settle the damages about what happened. So the second mistake that most people make, or can make, is not taking the charge seriously and just going in and pleading guilty. Well, I got charged with hit and run. Your Honor, I'm just going to plead guilty because I did it. I made a mistake. I'm going to throw myself on the mercy of the court. Please just give me a fine and let me go. Well, that all sounds good, except the penalty for a hit and run charge, especially a hit and run attended charge, is totally crazy. If you're convicted of hit and run attended, and again, that's if you run into a car driven by another person and you don't fulfill your requirements by giving them your information, if you're convicted of that hit and run attended, you lose your license for a year, 12 months. And that is a long time, especially when you realize the license suspension for a first DUI is much less than that usually. A first offense DUI has a license suspension for only 90 days in most cases. Now, if you're twice the legal limit, it goes up to a year. However, just think about that. You're going to have a much worse license suspension for tapping that Toyota Corolla in front of you and being afraid and not stopping, or not understanding that you ran into the car and not stopping. In that case, you get a 1-year suspension if you're found guilty. You're better off, well, you shouldn't do this, but just imagine, you get a DUI, you tie one on, you blow a .13, you don't run into anybody, you get pulled over for speeding, and now you get only a 90-day suspension. So you don't want to just go plead guilty to hit and run, not only because we can get it dismissed more easily than most cases, sometimes, but also because the penalty for a conviction seems out of line with other statutes. So don't just go plead guilty. Get yourself a public defender, get yourself a private attorney. Make sure you defend the case, because results can be much better in a hit and run case than in other types of cases. Finally, the third mistake that people make, I think, from my opinion, is paying too much for their defense attorney on a hit and run charge. A hit and run charge with a qualified and experienced defense attorney is going to be easier to handle than other types of cases. It doesn't mean it's going to be easy, but it will be easier. So it should be a lower rate than average. So if you're interviewing attorneys, ask them, what do you normally charge for an assault? What do you normally charge for a DUI? And what are you going to charge me? So if that number isn't less, then that would give me some concern if I was out interviewing attorneys. So those are the three mistakes that we see people make when defending hit and run charges. If you have any further questions, you can give my office a call. Again, my name is Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. We have been doing criminal defense work for over 20 years, all throughout Washington State. Our office is in Lynnwood. I was a prosecutor for 7 years before doing defense work, so I think I understand both sides. And if you need anything, just give us a call and we'll be there for you. Thank you.